Be ready? Start. The question for determination before the board is whether juvenile in conflict with law has committed the offence under section 12 of the Act. Stop stanza. In order to determine the above question, the evidence on records have been analyzed and appreciated vis-a-vis prosecution version. Stop. Our findings are outlined in subsequent paras. Stop stanza. To prove the essential ingredients of accusation against the juvenile in conflict with law, the prosecution first proved the factum of the prosecutrix being minor child so as to attract the offence under section 12 of the Act. Stop. Upon it, PW5 Pradeep Kumar proved the birth certificate of the prosecutrix PW3 issued by registrar within bracket birth and death. Stop. As per said certificate, the date of birth of the prosecutrix stated to be 7/12/2007. Stop. As per final report, date of birth of juvenile is 13/9/2007. Stop. The date of alleged incidence of crime is stated to be 26/4/2021. Stop. The correlation of date of birth of prosecutrix with the date of alleged incidence of crime lead to conclusion that she was of 13 years, 4 months and 19 days on the day of alleged offence. Stop. No counter evidence on this aspect laid by the defense. Stop. So, conclusively, the prosecutrix was below 14 years and so minor child for the purpose of offence under section 12 of the Act. Stop stanza. Nextly, the star prosecution witness PW1 prosecutrix in her deposition before the board has specifically attributed the allegations levelled against the juvenile as levelled in the complaint. Stop stanza. Nextly, in corroboration to the testimony of prosecutrix on the aspects of committing sexual harassment by juvenile, the testimonies of PW5 and PW8 are relevant. Stop. The appreciation of evidence of PW5 and PW8, this board lead to conclusion that on the said aspects, the testimony of PW5 and PW8 in hearsay 1 and so admissible in evidence. Stop. PW1 has specifically stated in her cross-examination that she narrated the incidents only to her father when she returned to her home. Stop. Thus, on the said aspects, testimonies of PW5 and PW8 are admittedly hearsay 1 and so of no avail to the prosecution. Stop. Next comes the reliability aspect of material prosecution witness PW5 and 8. Stop. As far as the testimony of PW5 is concerned on the material aspects of offence under section 12 of the Act, the same is hearsay 1 and so inadmissible in evidence. Stop. Next comes reliability aspect of evidence of prosecutrix PW1. Stop. The prosecutrix is victim in the case whose evidence is in the same category as an injured witness and so accorded with special status of evidential value to it. Stop. The evidence of victim prosecutrix must be given due weightage and her statement is generally considered to be very reliable and it is unlikely that she would spare the actual culprit in order to falsely implicate someone else at the cost and risk of loss of her reputation, modesty and character. Stop. So the testimony of a prosecutrix has its own relevancy and efficacy. Stop. The incident is of 26/4/2021 at about 5:15 p.m. FIR was registered on same day without any delay. Stop. The testimony of victim PW1 is corroborated on material facts from averments of complaint and her statement recorded under section 164 CRPC 1973 proved on file as PW1. Stop. Thus, the evidence of the prosecutrix victim witness should be relied upon unless there are grounds for the rejection of her evidence on the basis of major contradictions and discrepancies therein. Stop. The evidence of victim prosecutrix has greater evidential value and not to be discarded lightly unless compelling reasons exist. Stop. After going through her entire evidence, this board finds no material discrepancies or contradictions in her testimony so as to discard her evidence. Stop. In her cross-examination by learned defense counsel, nothing material revealed so as to impeach her credibility. Stop. It is beyond common parlance of human conscience that one may falsely implicate one at the risk and costs of esteem, prestige, modesty, and character of one's minor daughter, especially in a rural village community. Stop. Even if some dispute exists or enmity exists between parties, no father or mother would like to put at stake the reputation, modesty, and character of one's daughter for the sake of revenge by false implication in such offences. Stop. Thus, resultantly, nothing revealed in cross-examination to discredit the evidence of the prosecutrix. Stop. So her testimony is held to be reliable. Stop. Reliance is placed on Honorable Supreme Court judgment in case titled Shekara versus State of Karnataka 2009 within bracket 14 SCC 76, where in it has been held that a victim of molestation and indignation is in the same position as an injured witness and her testimony should receive the same weight. Stop. Stanza. Nextly, now coming to evidence of the PW1 prosecutrix qua specific offence under section 12 of the Act. Stop. As far as essentials of offence under section 12 of the Act are concerned, the same are evident from the prosecution evidence. Stop. Stanza. We have given our thoughtful consideration to the entire issue that arises in this matter for our consideration. Stop. The directive principle contained in Article 45 has made a provision for free and compulsory education for all children up to the age of 14 years within 10 years of promulgation of the Constitution of India, but the nation could not achieve this goal even after 50 years of adoption of the provision. Stop. It was felt that though the Government of India, in partnership with state governments, had made strenuous efforts to fulfill the mandate, and though significant improvements were seen in various educational indicators, the ultimate goal of providing universal and quality education still remained unfulfilled. Stop. In order to fulfill that goal, it was felt that an explicit provision should be made in the part of the Constitution relating to fundamental rights. Stop. Right to education is now a guaranteed fundamental right under Article 21A. Stop. It commands that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. Stop. The state at present is under the constitutional obligation to provide education to all the children of the age of 6 to 14 years. Stop. The state by virtue of Article 21A is bound to provide free education, create necessary infrastructure and effective machinery for the proper implementation of the right and meet total expenditure of the schools to that extent. Stop. Right to education guaranteed by Article 21A would remain illusory in the absence of a state taking adequate steps to have required number of schools manned by efficient and qualified teachers. Stop. Before teachers are allowed to teach the children, they are required to receive appropriate and adequate training from a duly recognized training institute. Stop. It has been observed by this court that allowing ill-trained teachers coming out of unrecognized institutes or licensing them to teach the children of impressionable age contrary to the norms prescribed will be detrimental to the interest of the nation itself is the sense that in the process of building a great nation, teachers and educational institutions also play vital role. Stop. In cases like these, interest of individuals cannot be placed above or preferred to larger public interest. Stop. Such in the importance of proper training to the teachers before they are allowed to teach the children of impressionable. Stop. Over.